మలబార్ గోల్డ్ అండ్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డ్ అండ్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్. $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి 3rd యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TV Asia Telugu. మీ అందరికీ 3rd యానివర్సరీ శుభాకాంక్షలు.
Hello and welcome back to yet another fabulous episode of our talk show with experts. Manato unnar mana immigration expert Rebecca Chengaru. Rebecca, welcome to the show.
Thank you for having me.
Thank you. This show has been brought to you by Malabar Jewelers. They've opened a brand new store in Dallas. Don't wait any further. Go with the gold rush and buy yourself the best. Supported by movers.com and AHA OTT platform. Watch us on Yup TV, Facebook, YouTube, Sling TV, World BB TV and Dish Network. All right, and coming back to the topic for today. So Rebecca, we've been, sort of tracking the dates. We've been tracking, various announcements that have been, coming out from USCIS about, the green cards and the backlog, and also, with how COVID has affected the plight of people getting their green cards and how many are being processed and stuff. So in a way, we are sort of caught in limbo. So what do you have to say about the plight of all the Indian families in the green card backlog? Do you foresee any sort of near future, good news coming along, or do you not? What exactly is happening? Tell us some more.
Sure. Yeah, well, as far as any near future developments, unfortunately not. So kind of our this limbo state that we're talking about, that's sort of based on our expectation that there isn't going to be much forward movement in the visa bulletin, not only for the rest of this fiscal year, which goes through September 30th, but also for the next several years. That is based on sort of calculations that we've done based on data from the State Department, from USCIS, on how many applications they took in the last few years, where the dates are now, and knowing that the visa bulletin movement, it's going to go back basically to how it was pre-pandemic, this upcoming fiscal year. And so, even now already we're starting to see those effects with EB1 becoming backlogged, which it hadn't been the last few years. Even rest of world starting to get backlogged, other countries other than India or China, which typically are never backlogged, they're starting to get backlogged as well. And so that definitely doesn't bode well for Indian nationals who have the longest wait time. So barring any change in the law or the change in the administration's interpretation of the law, unfortunately, it is going to be this limbo state for Indian nationals who are in the green card process right now. Kind of the main takeaway is that anyone in this green card line needs to be prepared for a very long wait going forward. Rahul in our office, he's a marathon runner. He refers to it as, we need to be ready for it to be a marathon. It's unfortunately, we're not going to see the type of movement in the visa bulletin that we saw the last few years, 2020 through 2022. That was essentially just a product of the pandemic. And so barring also some sort of global event like that again, if operations go back to normal, it's going to be a very long, really decades long wait for Indian nationals. So yeah, it really leaves not only these workers, but their families in this limbo state. Getting the I-140 approval only brings you so far. You can get H-1B extensions indefinitely, but the H-1B is still, a very restrictive state to be in. You can't change to whatever employer you want to. You still have to depend on employer sponsorship, on an application to be filed every time there's any, significant change in your job duties or work location, that sort of thing. So it really restricts people who are in that state. People who have an EAD, who are able to at least file the I-485 in the last couple years, they have a bit more flexibility because they have that EAD, but it still kind of binds them to having that full-time job offer in a same or similar occupation. So it really, it restricts people, and you're just in this state where you can't, you're going towards the green card, but we just don't know how long they'll be in this state where they have to kind of depend on other factors before they can get there.
Got it. So if you were to sort of take a guess, so for people who are filing now, what kind of wait times are they looking at realistically?
Realistically, again, if there isn't any change in the current law or interpretation of the law, our office has calculated it out, and it's, something like 120 years at the last count. And that was not just our figure. There was a similar study by the Cato Institute, which also kind of did an analysis of realistically, based on the number of new green cards issued each year, if the per country caps stay as they are, I think their estimate was even a little more than ours at last count. But so it's not even, a real, no one will live that long to be able to to wait for the green card that long. So it really, shows the need for a fix in the system, for a change in the law or in the administration's interpretation of the law.
Now, what you're talking about, is it limited to H1 based green cards, or are there like other ways to get green cards, for people who are looking?
There are other ways. Unfortunately, for the most part, anything related to the green card is always going to still be based on country of birth. So country of birth will still always be factored in, whether it's EB2, 3 or EB1. The category, the EB category can help a bit in terms of where you are in line. It can move you ahead in line. So we have definitely had people go for the EB1 category more in the last couple years. And we've talked about it in, I know y'all have talked about it in these shows also in the past, which ways you can get into EB1 to kind of get farther ahead, or the EB5 category, which is the investor category. But those are still subject to the country of birth calculations. And there are also a lot of factors with the EB5 that can make it quite complicated. But yeah, the way the system is now, any possible way of getting a green card is still going to be based on country of birth, which of course no one can do anything about, no matter how qualified or how exceptional they are. It still will always be based on that.
Just out of curiosity, so which countries are expecting the least amount of wait time, you know?
So in the employment-based fields, really the main countries that have significant wait times are India, and second place is China, to a bit of a lesser extent. Their visa bulletin is kind of hovering around 2018, 2019 right now, and it could also stay there for quite a while. But other than India and China, really any other country that someone is born in, there is minimal wait. There's a little bit now, like I said, because there is starting to be a backlog even in the rest of world categories, but it is nothing compared to the wait time for Indian nationals, or to a lesser extent Chinese nationals. For anyone else who's born in any other country in the world, it may be an additional 1 or 2 years that they may have to wait if it's backlogged a bit. Yeah.
Thank you so much for that. And on that note, let's start taking our callers for today. Let's take our first caller. All right, caller with number ending in 4795. 4795, we're ready for you. Hello?
Hello, Nitya garu. Are you able to hear me?
Yes, ma'am. We're able to hear you. Please go ahead.
Okay. Thank you, Nitya garu. Thank you, Ms. Rebecca, for taking up the call. So my question is, priority date is August 2014, and both I-485s are under EB2 and EB3. We got EAD and AP combo card under EB3. So my question is, in case if I want to travel to India, can I use my AP? And what are the docs? What docs are required at port of entry while coming back from India? And then my follow-up question is, on return, can I continue to work on H1B?
Okay, so
or if I use that AP, will I be bound to EB3, because that was the category that I got issued the EAD and AP under?
Mm-hmm. Okay, yeah, so it should be fine for you to use the EAD and AP, so this advanced parole that's related to your EB3. If you need to travel, it's perfectly fine to use that advanced parole if that I-485 remains pending. That's all that's required for that advanced parole to be usable, is that that I-485 that it was based on is still pending and in process right now. So if you do use it to travel, I think the second question was the documents you would need when you are coming back into the US. You would just need the combo card and a copy of your I-485 receipt notice. So the I-485 in the EB3 category, that receipt notice related to that advanced parole. That's pretty much all the documents you need. You don't really need an employment verification letter technically. And then when you are coming in, also just be aware there is a possibility that you will be put in what's called soft secondary inspection at the border. That's where it doesn't mean you're in trouble or that they think you have fake documents or anything like that. That is fairly routine for some ports of entry where they just need to kind of run the I-485 and confirm that it's still pending. So it may take you a bit longer at the border to, get through Customs and Border Patrol, but don't be concerned. That's pretty standard. So yeah, that's what you would need when you come into the US on advanced parole. When you are here on advanced parole, technically when you enter, you're using advanced parole. However, if you want to continue using your H-1B, if it is unexpired, if the I-797 approval notice for your H-1B status is not expired at the time you are coming into the US on advanced parole, you can continue on that H-1B. Basically, there is a policy where USCIS says that you can extend that H-1B. It's a bit of a gray area from the time that you enter in. Are you on advanced parole or H-1B status? But as long as that H-1B is valid, people have been using the H-1B without a problem.
Oh, okay. So if I use the AP, I won't be bound to the EAD because right now, because of various issues, I don't want to use my GC EAD. I still want to bound to my H-1B. So using AP doesn't mean that I'm using EAD too.
Right. Yeah. Not unless you provide that EAD to your employer for some reason and ask them to basically consider that the basis of your employment authorization. But if you don't, if you just come in on advanced parole, then you can continue on H-1B. And there are some situations where you would want to do that. For example, if you have a spouse or family members in H-4 status, so you want them to continue in H-4, for example. Yeah, so you can continue on that H-1B.
Okay, so after coming back to US, do I need to provide any document supporting that, hey, I want to continue on H-1B, or it's automatically, unless and until I provide EAD, I would be considered under H-1B, right? I need not provide any supporting documents so that I'll make sure I'll be on H-1B.
Yeah, that's correct. Because from your employer side, for their purposes, the I-9 only needs to be revalidated if the document they have on file for you is about to expire. So they are only supposed to come to you to ask for a new work authorization document when your H-1B is about to expire. If at the time you left the country, your H-1B was still valid. So they should not be, asking you for a new work authorization document, and you're not obligated to provide them with one either.
Okay, thank you. And the same thing applies to H-4 too, right?
Yes, yeah. So if you
have
have a spouse, for example,
then the same thing applies to H-4 too.
Yeah. So the H-4 would also continue. The H-4 EAD, if there is one, would also continue to be valid.
Oh, okay. Thank you so much, Mr. Beck.
Thank you, ma'am.
Thank
you so much for calling, Andy. All right.
Thank
Before
you,
we take
Rebecca.
our
Bye.
next caller, thank you, Andy. Rebecca, there's a question for you. This is from Ravi. Says, I have an RFE from a field office on my pending 485, received December 20th of 2022. Last day to respond is March 20th of 2023. Latest USCIS COVID flexibility extends 60 days. Am I eligible for 60 days beyond March 20th?
Unfortunately not, unless there is some kind of very extraordinary situation, but it's pretty rare. I don't think we've ever successfully really argued for an extension beyond the 60-day grace period that's already there under the COVID guidelines. So yeah, for most RFEs, USCIS gives kind of a 90-day initial response time. They've been extending that by 60 days throughout most of the pandemic, and that is still continuing. So you have about 5 months. So I would say it's unlikely you'll be able to get a further extension beyond that 60-day grace period, unless there is something that you can show. For example, if the RFE is asking for a document that is in process and you just can't provide it yet, I would still definitely respond within that 60-day grace period. Send in something within those 60 days, but if you don't have what they're asking for, explain why you don't have it. Provide documentation to show you're trying to get it and why it is not yet available. And in some of those cases, USCIS won't really extend the deadline, but they might issue a second RFE, basically giving you additional time that way. So if you need that additional time, send in something to, explain it, show why you need the additional time, but definitely don't, just let that 60 days expire without sending in anything, because that will trigger an automatic denial.
Got Thank you. Let's take our next caller. All right, caller with number ending in 3337. 3337. We're ready for you now. Hello? Caller with number ending in 3337. Ready for you now? Hello? All right, let's place the caller on hold. We'll attempt to contact them again. Caller with number ending in 5070. 5070. We're ready for you now. Hello?
Hello.
Hello, sir.
Hello. Can you hear me?
Yes, sir, we can hear you. Please go ahead.
Yeah. Namaste, Nitaji. And hello, Rebecca. This is Ram here. So we have applied for our 485 under EB1C category, and our priority is current 2012. And now that our 485 is pending, we have also applied for our Canadian citizenship. So my citizenship of birth is India, but now we applied for Canadian citizenship. So my question is, what happens to my pending 485 if we get the Canadian citizenship prior to the form being adjudicated? Or what if after we get the green card, we have to get the Canadian citizenship? So two questions. One is before getting the green card and after getting the green card. So I just wanted to know what I need to do.
Right. So it shouldn't really affect your I-485 if your Canadian citizenship gets approved while your I-485 is in process. I don't think you would need to really update USCIS. You can, because I assume when you filed the I-485, at that time your country of citizenship was India. So you'll need to give up your Indian citizenship is what you're saying, right? When you become a Canadian citizen?
Yeah. Yeah,
okay.
Yeah. I need to give up my Indian citizenship, but on the 485, we have mentioned that the country of citizenship is India. So if I end up getting the citizenship prior to the form or we getting the green card, do I have to notify USCIS saying, hey, now I'm no more an Indian citizen, but I'm a Canadian citizen? So.
Right. I don't think there is an obligation to do so, but to be on the safe side, what you can do is just try sending in a letter to USCIS with a copy of your Canadian passport, which will, when you get your Canadian passport, and if your green card hasn't been approved yet, send in a letter to USCIS notifying them that your citizenship changed while the I-485 was pending with a copy of your Canadian passport, and just so they can update their file, although I don't think that's absolutely necessary, but to be on the safe side, you can do that. Just send it into the service center where it's pending right now. If your Canadian citizenship comes in after your green card is approved, I don't think you have to notify USCIS at all. It won't really have any impact. So then at that point, you'll use your Canadian passport plus your green card to travel. The main thing to kind of be careful about is that once you do get the green card approval, you'll be considered a permanent resident of the U.S. If you spend too much time outside the U.S., for example, if you relocate to Canada for some reason or will be spending a lot of time there, you have to be careful about spending too much time outside the U.S. at any one time. The basic rule is that if you'll be outside the U.S. for more than 6 months continuously, we recommend applying for the reentry permit. It's definitely required if you will be outside the U.S. for more than 1 year continuously. So if
we are currently in we are currently in the States, and we continue, or we plan to continue, in the States. So that should not be a problem. But then on the green card, the country of citizenship would be mentioned as India, and if we show the passport as Canadian, will there be a problem at the border or the port of entry?
No, there shouldn't. Especially while the green card is in process, like we said, the green card issuance is based on country of birth, not necessarily country of citizenship. So that's why it wouldn't really affect the I-485 while it's in process. And then, after you get your green card, just any valid passport that you have, plus your green card will enable you to travel.
Okay. Okay. Thank you so much. So I think the preference is to wait until we get the green card, and then because it's on us on how far we can push taking the oath of the Canadian citizenship. So I just want to time it well. But with the given time frames, I don't know when our form will be approved, even though we are current, and I filed it in January.
Okay. Yeah. Yeah, that would be fine if you are able to wait until after the I-485 gets approved here in the U.S.
Okay. Thank you so much. Thank you so much, Rebecca. Thank you, Nitya.
Thank you, sir. Thank you so much for calling. All right, let's take one more question before we go to our next caller. Just give me 1 second. Yes. All right. This is from Sajita Pakala, says used advance parole to return to the US in December. I-94 shows admitted till December 28th of 2023. Does the I-94 need to be extended to stay in legal status?
No, you don't. So yeah, that is kind of standard. When you enter the U.S. on advanced parole, the I-94 will have the class of admission as like DT or something like that. And then they will always put the end date as pretty much a year from the time you entered. So the I-94 will show kind of a 1-year period of admission, but unlike when you enter on H1 or L1, H4, anything else like that, that I-94 end date doesn't really govern how long you can stay in the U.S. That's good that you're checking, because we always do emphasize that, you know, people should check their I-94 when they are coming in after every entry to make sure it's correct and to make sure the end date is correct. But coming in on advanced parole is the one time where you can kind of ignore that end date. Basically, once you come in on advanced parole, you are authorized to stay in the U.S. as long as your I-485 application remains pending. So you don't need to take any action to really extend that I-94 or, yeah, do anything else. You don't need to travel again prior to December 2023. Yeah, you can continue staying here.
Got it. Thank you. All right, let's take our next caller. All right, caller with number ending in 6478. 6478, we're ready for you now.
Hello, Nitya Garu. Hey,
Hello,
Rebecca.
sir.
So my question is, I'm currently on H1B and my I-140 is approved. So on H1B, I'm working for an employer and I work for 2 clients, client A and client B. So with both the clients, I'm currently billing 40 hours a week. So now my client A wants me to become a full-timer, and they are in the process of doing my visa transfer. So my question is, once the visa transfer is completed with the client A, I still want to continue working for the client B. So can I ask my current employer to file a concurrent H1B visa for me so that I can continue with the client B?
Yes, yes, you definitely can do that. You could also, if employer A, which is kind of your current client A, who is doing the transfer application now, if they are willing to just file your application as a concurrent filing, then that would kind of take care of it. You wouldn't need your current employer to then file another concurrent application. But if you don't want client A, for example, to know that you intend to continue working for your other employer, client B, then you can just have client A file the H-1B transfer, yeah, and then have your, by then, former employer file a concurrent petition for you to authorize you to work for client B at the same time. Just be careful that in that, make sure to time it correctly, because if there is a gap of time from the time that you start working for client A full-time, once you start on their payroll, if the concurrent application is not yet filed, you can't be working for client B at that time. So just be careful with the timing of those applications. If you want to continue working for both without interruption, you may want to get the concurrent application started too.
Got it. So I have to wait for the concurrent visa to be approved for me to continue working for client B.
Not necessarily
And
to
one
be
more question,
approved,
right? So
just filed. So the concurrent
Just
petition just needs to be filed, not approved.
okay. Yep, got it. And I can work on two W-2s, right? Like
Yes.
one with the client A and one with the employer. That should not be a problem.
Yes, that's fine.
And
as
my
long as you
I-140
have a
also,
concurrent.
okay, got it. And my I-140 also is with my current employer, and it will continue to be with my current employer, and that should also not cause any problems, correct?
Yes, that's fine as long as, yeah, your current employer keeps the I-140 approved. Yeah, that won't, working at the same time for a different employer won't change anything.
Okay, yep. Thank you very much. Thanks for taking the call.
Thank you, sir.
Sure.
Thank you so much for calling, Andy. All right. Before we take our next caller, let's take a question. This is from Priyank0329. Says, received a notice from USCIS saying we are temporarily pausing work on your application because an immigrant visa number is not immediately available to you. What does this mean? Priority date is Feb 2013, EB2. I have an approved EAD and advance parole.
Okay, yeah, so that message has been pretty common starting last September. So this caller, like a lot of applicants, would have submitted their I-485 application when the priority dates were current for them, but they were one of the kind of unlucky ones who didn't get the I-485 approval by early September 2022. That was when the green cards ran out last year. So we have heard of a lot of cases of those I-485s. They remain pending, but because USCIS can't take final action on the case until the priority date is current, that's kind of a standard message that shows up in the case status. And then I'm a little surprised that it's taken this long. If it just recently updated to this, it's been, about 6 months by this point, but it doesn't surprise me too much because I know a lot of the I-485s were at different field offices in September. At the time the green cards ran out, USCIS had distributed I-485 files kind of all over the country to try to get as many approved as possible. And so what it looks like is that different field offices are working at different paces to kind of deal with these I-485 files they have left. And so my assumption would be if the case status just recently updated to that message, that the field office where this caller's file is just recently kind of got around to updating it.
Yeah, okay. But what does this kind of mean for this person? Is it's...
Yeah, so the I-485 will remain pending. The EAD and AP can be used. They can be renewed while the I-485 remains pending, but there won't be final action, final approval on the I-485 until the visa bulletin reaches 2013 again.
Got it. Okay. Thank you. Okay, let's take our next caller. Okay, caller with number ending in 3337. 3337, we're ready for you now. Hello?
Hello?
Hi, ma'am.
Hello?
Hi, ma'am. Go ahead, please.
Hello, can you hear me?
We can hear you. Please go ahead. Yeah.
Yeah, my question is, okay, am I audible?
Yes, you're completely audible. Go ahead, please.
Okay, thank God. Yeah, so my question is, actually, I am recently laid off from my company, and within 50 days, I have joined a new company. Okay?
Okay, go ahead.
Hello?
Yes.
Yeah, and I have joined just on H1B receipt notice without approval. I don't have approval, just on notice I have joined the new company. So, like, I have already consumed 50 days. Now, if my new company, which I have joined on the receipt notice, if they lay me off in 20 days, so will I be out of status, or will I have 60 days grace period from the day company B laid me off? So basically, I wanted to know this 60 days grace period, does it get reset with the receipt notice, or it gets reset once I have the H1 transfer approval?
Right. Yeah. So unfortunately, the 60-day grace period will only reset if you have another approval notice from this new company that you've transferred to. So one of the rules about the 60-day grace period is it has to be based on an I-797 approval notice that is unexpired. So if, for example, so the timing wise, if you are laid off from this new company, but your original 60-day grace period has not expired yet, you still have until the end of that original 60-day grace period to have another application filed for you. But it sounds like that original 60 days is about to expire, like within 10 days or something like that. So if a layoff from this new company happens after the original 60 days, if it's based on, if your transfer application is still pending at that time, unfortunately, you won't have a new 60-day grace period. You would be kind of considered out of status, but if you could get another application filed quickly enough, and if the new application includes an argument that there were extraordinary circumstances around this, transfer that didn't work out, you may still be able to get another transfer approved, but it's not guaranteed. So the 60-day grace period is kind of a guaranteed grace period. If you're outside of that and the transfer is not approved, I would say, depending on the timing, if you can get another application filed within about 30 days, that's not an official grace period. But in our experience, if you can file another application within about 30 days and basically make an argument asking USCIS to excuse the out of status time, it's called the nunc pro tunc argument, and you need to include that upfront in the new application. I would say there's a pretty good chance USCIS will still approve it, but it's not guaranteed. If this transfer that's pending right now gets approved and then you are laid off, then you do get a new 60-day grace period from that termination date.
Sorry, like the last part I did not understand. Like if my H1B transfer is in progress and I get, right now I have a receipt, and if my H1B transfer is in progress, now if I get laid off, then do I have 60 days?
No. If you are outside the original 60-day grace period, you do not have a new 60-day grace period.
No.
Like I said, you don't have a new guaranteed 60-day grace period.
Right now, I am within my 60 days grace period, and if my employer lays me off within this 60 days grace period, then based on the receipt, I will have another 60 days. Am I correct?
No, that's not right. So you'll have the remainder of the original 60 days. So if you are laid off at day 55 of your original 60-day grace period, then you'll have 5 days left in your grace period. But you won't get a new 60-day grace period unless the transfer application is approved.
Okay. So to get a new grace period, I must have a transfer application approved.
Right. And the termination would need to be after that approval. So if you are concerned about a potential termination from this new company, it might be a good idea to upgrade to premium processing if it's not already in premium processing. And if the company won't pay for the premium processing fee, you have the option of offering to pay the premium processing yourself to try to get that approval faster, so that at least if there is a termination, you will get a new 60 days if it happens after the transfer is approved.
Okay, and can we file multiple transfers? Like,
Yes, you can. You can have more than one transfer application pending at one time, but it does depend on you being in status at the time for a transfer to get approved. So basically, if you file an application for a transfer and this current transfer remains pending or gets denied, then the second transfer that you filed may not get approved because kind of the bridge application, the one that your status at the time was based on, if that falls through either by being denied or, you know, the company withdrawing it because you're no longer working for them, that could affect a further transfer that you filed while you were out of status. Like I said, there are arguments that can be made, like the nunc-pro-tunc argument, to try to get around that, but those aren't guaranteed. It's still based on USCIS's discretion, but I would still definitely make that argument if I was in that situation.
So like I was under the impression the different transfers are independent of each other. So that is why like if multiple transfer, like if one is going wrong, then other might go fine. So we can join that. Is that not the case?
Not entirely, because the transfer application's success depends on whether you are in status at the time it is filed. And whether you're in status at the time a second one is filed will be based on whether the current transfer ends up getting approved.
Sorry, I did not understand. So I'm within status, so I have time remaining. So if I file 2 transfers, then what will happen? Is that a bad thing for my profile or what?
If you file another transfer within the original 60 days, then that could be fine, but it will need to be filed in the next like 10 days or so.
Okay, but it is completely fine to file, right? Another transfer too.
It is, but like I said, it depends on the timing and the status. I would probably speak with an immigration attorney since it does depend a lot on whether another transfer is filed within the original 60 days or afterwards, whether this current transfer gets approved or not. So there are a lot of factors that go into determining how well an additional transfer might go. So I would probably speak with an immigration attorney one-on-one to kind of go over your documents, work out all the timings and see what can be done to file another transfer and how to make sure it gets approved.
Okay, yeah, thank you so much. That was my question. Thank you for being patient.
Thank you, ma'am. Thank you so much for calling us. All right. And before we take our next caller, we have a question. It says, this is from Officially Me. It says EB2 and EB3 went up until 2014, 2015 in the past. In that process, many people with the priority date of 2013 and 2014 got their GCs as well before the dates got retrogressed. Does that mean that when the dates become current in 2013 or 14 in the future, the process will be faster as many got their GCs already?
Potentially. It's really hard to say because a lot of even the data that we have from the government is a little unclear because we don't know how many. The data that we get from the government includes all I-485 applications that are filed, but we know that not every application represents a different person or a different family because a lot of people downgraded. So a lot of people have applications in EB2 and EB3. So, you know, when one of them gets approved, they're obviously not going to pursue the other one. It'll just get closed. So that is possible that when the dates become current again, it may go a bit faster because a number of people with those priority dates have already gotten approved. But we don't know how many have downgraded, how many duplicate applications there are out there. But definitely I would say there's a better chance of that going faster than priority dates that are past 2015 or 2015 and forward that, you know, never got current in the visa bulletin.
Okay, makes sense. Thank you. All right, let's take our next caller. Okay, caller with number ending in 2870. 2870, we're ready for you now. Hello?
Hello?
Hello, ma'am?
Yeah, can you hear me?
Yes, we can hear you, ma'am. Please go ahead.
Yeah. Hi, my name is Radha. Hi, Nitya and Becky. Thank you for taking my question.
Go ahead, please.
Yeah. So me and my husband, we have the green card.
but my son is outside of US for education purpose. And then last year, when the date was current, he came here and we filed 485 for him. But later on, before he gets the biometric, his college started and he had to leave the US. So since he was out of US, then we filed I-130. And while he traveled back, he already have the B1B2 visa. But because that time 485 was pending, he was not able to come back to US on B1B2. But now, recently USCIS has denied 485 because he couldn't appear for the biometric when they sent notice 3 times. And now his I-130 is only pending. But during summer vacation, he wants to come back to US to visit us. So my question is, can he come on B2 visa now when I-130 is still pending?
Unfortunately, it will be very difficult, I would say. Yeah, that's the difficult thing once there is an application that is filed and on record that shows that that person does intend to get a green card eventually in the US, that kind of cancels out their B1B2 visa or any other visa where you have to have only temporary intention. Yeah, so I would say probably not, unfortunately. At this point, it sounds like he'll be going through the I-130 process and then applying for the green card through the consulate, right? In his home country where he's going to school. Okay. Yeah, so that can take a couple years, as you're probably aware, depending on that particular consulate and how quickly they can schedule an interview after the I-130 is approved. But yeah, unfortunately, there aren't really many solutions in the interim for him to come into the US as a visitor. So I would say probably you should be prepared for him to not be able to come into the US until his green card is approved through the consulate.
Okay, but what if he has a strong reason to show that why he wants to visit US and then he will go back? The main thing he wants to come here is to appear for the USMLE exam because he is a medical student studying outside. So he wants to come here, appear for the USMLE exam and then go back to the country where he's studying now. So can this be a solid reason?
I don't think coming in to sit for a medical exam would fit under any exception to that, as far as I'm aware. But yeah, at this time, like unless he is planning to come to the US, yeah, unfortunately, yeah, I can't really think of anything because even the F1 student visa also requires non-immigrant intent. The only visas really that allow you to come into the US while you have the green card process actively ongoing are the H1 or the L1. So unless he is going to be sponsored for one of those visas by an employer, then yeah, I would say probably he won't.
No, he's student.
Yeah.
Yeah, he's student, right? So he will not find an employer to sponsor. And I forgot to mention one thing. When our green card were in processing, we filed I-824, follow to join application, right? And when our green card was approved, that time his I-824 is also approved. But because now the dates are retrograde, he cannot use that for consular processing. So with I-824 approved, can he come or no?
Also no, unfortunately. Yeah, so it looks like the main path for him to be able to come here will be the family-based I-130 route, but that will kind of depend on when he can get that final interview with the consulate.
Yeah, and that's taking long time. That's where we were little worried because he cannot come to see us and appear for the USMLE.
Right. Yeah, it is very difficult that kind of during during that time,
Rebecca,
then
does this sound more like something where they probably have to talk one-on-one with an attorney to sort of figure out what other options they
yeah,
might have
you could
at
also
this
speak
point?
with like maybe a family-based attorney also to see if they're aware of any exceptions that this would fit into.
Mm-hmm.
But as far as I know, there aren't very many. Like just in my personal experience, I remember too, like my family from Taiwan, when we
Mm-hmm.
sponsored them for
Mm-hmm.
the green card through the family-based route, there was like, and it's also a very long process on the family-based side, like 10 plus years for them. And that whole time, like my cousins, aunts and uncles could not come to visit us here. We had to go there to visit them.
I got you. Yeah. Okay.
Rebecca,
Yeah.
I
Anyway,
remember
then we
Rahul
have to wait.
mentioning something about reapplying for a B1 or B2 visa each time they try to come in or something like that, to just show
Mm-hmm.
intent that I remember last episode or the previous episode he mentioned something like that. Would that be something that they can look at maybe?
Yeah, you can try. So he can try maybe to, so on his
Mm-hmm.
last entry, if he was denied entry on the B1B2, that visa in his passport would be considered invalid now, even if it is not expired. But he can try reapplying at the consulate for the B1B2. He can try, but my guess is that it would be difficult to get a new B1B2 visa. But yeah, it doesn't hurt to try.
Mm-hmm.
Okay.
Okay.
Right.
And
Thank you, ma'am.
if he can apply and get the new B1, B2, then he can try coming here, right?
Yes. Then at the border, as long as he has the documents that kind of back up the reason he gave to the consulate, that should be fine.
Okay. Okay. Got you.
Thank you,
Okay.
ma'am. Thank you so much
Let
for
us
calling.
try that route. Thank you. Thank you so much.
Thank you. All right. And before we take our next caller, I have a question for you. This is from Dharmil Pitwa. Says USCIS says that they're processing first come, first serve. My 485 was filed in September of 2022. Priority date is current, but still pending. I see some October filings are getting approvals.
Yeah, we know for a fact that the first in, first out processing is not correct. We don't know why USCIS insists on still saying that that's how they're processing things, because we also know, just based on our caseloads, we were tracking I-485s based on, filing date, service center, where it was filed, and when they were approved, whether they got transferred to another service center. So we were tracking all of that the last couple of years when, the priority dates were moving all over. And so we saw for a fact that there were applications that were filed later and got approved faster, just based on the service center that they happened to be at. Or in some cases, not even the service center. It really didn't make sense sometimes. In some cases, it was applications filed at the same time for the same family, a principal applicant, spouse, and a child. And one applicant's got approved and the others took 6 more months to get approved at the same service center. So yeah, unfortunately, that's the case, but at least for this caller or this person who wrote the question, it's not just you. It's not unusual, if that helps in any way. It's not just you, but we have noticed the same. But yeah, that's not true really on USCIS's side. It's not always first in, first out.
Okay. All right. Thank you. Let's take our next caller. Okay, caller with number ending in 4619. 4619, we're ready for you now. Hello? Please press *6 and to unmute your line. *6 to unmute your line. Caller with number ending in 4619. Hello?
Hi.
Hi, ma'am.
Hi, Nitya. Hi, Rebecca.
Hi.
Can you hear?
Yes, we can hear you, ma'am. Please go ahead.
Yeah, hope both of you are fine and doing good. And I'm Zainab here. So my situation here is me and my husband, we filed for EB2 cross chargeability, adjustment of status, and my husband is the primary applicant and I am the derivative applicant. So the problem I'm facing is like for my case, for us to get our green card and for the AOS to go, my and my husband case should be together. But the thing is, my husband's case, it has reached the Charleston field office, and my case, since I guess more than 1 year, it is stuck in the New York Buffalo field office. And I had raised a service request as well when I spoke with the USCIS customer service. And they told within 3 months, my file would get transferred to the Charleston field office. But it still hasn't been done that. So what I was planning is I was planning to go for mandamus, or in other words, to sue the USCIS. But I have a concern, like me being the derivative applicant, can I do the mandamus, or my husband, who is the primary applicant, he should do the mandamus? Like who should take the step? I want to know that.
Right. I believe it would be you, since you would be asking for your file to be transferred to be at the same field office as your husband's, but I don't know for sure. I will say that expert on litigation in our office is Stephen Brown. He's kind of the head of our litigation department. He has filed mandamus cases, I-485 delay cases, for cases kind of similar to yours, where the priority date is current, everything should be there to approve the case, but USCIS is just not moving on it. In this situation, for whatever reason, we don't know why they split up the cases of families who filed together to be at different service or field offices in different parts of the country. So yeah, that was going to be what I was going to suggest. If you've already tried the service request, ombudsman, congressman's office, litigation would be my recommendation. And if you do decide to pursue that, I would definitely recommend consulting with Stephen Brown in our office. He will kind of do an initial call for free to just discuss the case and let you know kind of what he thinks the options are and how it will look. But yeah, I would say you should have a very strong case. He'll be able to let you know for sure who the mandamus should be filed under, whether it's you or your husband.
Okay, so like just to say, like mostly it will be me, the derivative applicant, who should file for the mandamus.
That is my guess, but like I said, Stephen will have a clearer idea on who the mandamus would be filed under. I believe it would be you, because your case is the one that would need to be transferred to Charleston, and for that needs to happen for the cross-chargeability to be applied. But I don't know, it may also be able to be filed under your husband, since his application is the one that is also being harmed by the applications being split up right now.
Got it.
Yes.
So ma'am, it looks like you can just go onto the RN Law website, right, and contact them, to get
I would
consultation set up with Mr. Stephen, I guess.
Mm-hmm.
Okay. All right. Thank you, ma'am. Thank you so much for calling.
Thank you for clarifying my doubt.
Sure.
Thank you so much. All right. Before we take our next caller, I have a question. This one is from Arav Shah. It says, my L1A extended, and at the bottom of the approval, I can see the new I-94 date is mentioned. I have a pending AOS with a priority date of May 2022. My I-140 is approved. Can I go to my home country for stamping, or is it better to avoid any risk?
That's fine to go to your home country for stamping. I think they mentioned their I-485 is pending. So if that's the case, and if you have the advanced parole, if you already have it in hand, that would be the easiest way to travel. You could avoid the consulate altogether, but maybe the advanced parole is still pending. So in that case, if you do need to travel, you would need to get the L1 visa stamp before you return to the U.S. But that is fine. So if your I-485 is pending, if you depart the US without an advance parole, the main rule is that you have to be, at the time you depart, you have to be in valid H or L status. And when you come back, you have to be in valid H or L status if you're traveling without the advance parole. So if your L1 extension just recently got approved, it's valid. So there won't be any problem with you going for stamping.
Got it. All right. On that note, let's take our next caller. Caller with number ending in 9384. 9384, we're ready for you now. Please press *6 to unmute your line. Caller with number ending in 9384, *6 to unmute your line.
Hi, Nitya.
Hi, sir.
Hi, Nitya and Rebecca. Are you able to hear me?
Yes, sir, we can hear you.
Yes.
Please go ahead.
Hi, I have two questions, ma'am. First question is about H1B status. So my spouse was laid off from her previous job on January 11th. And as per the 60-day grace period, that grace period ends on March 12th, right? And, you know, she got a new employer and they got H1B transfer approval on March 6th. But she cannot start the job till March 20th because the new employer wants the H1B approved I-797 hard copy, while meanwhile the previous employer is still keeping her payroll on. So my question is that now that she's able to start the new job from March 20th, is her H1B status still intact? Because from March 12th till March 20th, she is not able to join the new employer. However, the petition was approved on March 6th.
Right. And you said that her former employer, the one where she got laid off, is still paying severance, or still has her on payroll?
Yeah, the base salary is still being paid. There is no gap in that.
Okay, I would say that she should be fine, even if there's that 8-day gap. I don't know, from her new employer side, if they were our client, we would tell them that they don't need to wait for the hard copy approval notice. Really, they can onboard her just based on the receipt notice if they wanted to, and especially now that it's approved. But if they are preferring to wait,
thank you. I have a second question too, which is related with advance parole. So as we all know that Department of State is going to have a pilot H1B stamping program in US. So I wanted to ask you, those people who are traveling to US on advance parole, would they be considered eligible for that? And, you may want to correlate it with the process which was 15 years back when this process was in at that point. Did they allow the advance parole people to file for H1B stamping from US? Because I think right now the regulation is not out, so you may not know officially. But I just wanted to know what was the rule previously when the H1B stamping used to happen in US.
Yeah, the new regulation or rule for the stateside visa applications is not out yet, so we don't know for sure. Under the previous program, I am not sure if your most recent entry, if it was on advance parole, I don't know if that made you eligible for the stateside renewal or not. We would need to look into that, but yeah, that probably would be a good indicator of whether the government will allow it this time. Even if they don't allow, for whatever reason, advanced parolees to do this stateside visa renewal, one fairly easy way to get around that would be to go to Canada or Mexico and do automatic revalidation, the kind of margarita switch that Rahul talks about a lot, where you don't need a valid visa stamp. If you go to Canada or Mexico for a period of 30 days or less, come back with an I-797 approval notice that has a valid I-94 on it, then at the border, CBP will give you an H-1B I-94, and then that should enable you to do the stateside visa renewal if they are requiring that your most recent entry be on, that visa class that you're going to ask to renew.
Okay. Yeah. Thank you. Thank you very much.
Sure.
Thank you, sir. Thank you so much for calling.
Thank you, Nitya.
All right, folks. Unfortunately, I know we have a lot of more people waiting on the callers list, but we are, as always, out of time. Rebecca, thank you so much for being on the show today and for helping all our viewers and our callers and people on the live chat as well.
Sure. Thank you for having me.
And to all our viewers, we'll be back with a new topic next week, same place, same time. Bring us your questions, bring us your calls. We'd love to talk to all of you. So please keep calling us with your questions. And until then, have a safe week. Thanks and bye.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డ్ అండ్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు.